Okay, this next section is going to move on from physical barriers to access, and we're going to move to the other part of Title III that we're covering in this class, which is the policies and procedures or auxiliary aids requirements. So we were earlier discussing barrier removal, right? And now we're discussing a failure to make reasonable modifications in policies, practices, or procedures where such modifications are necessary to afford goods, services, facilities, privileges, advantages, or accommodations to individuals with disabilities, unless the entity can demonstrate that making such modifications would fundamentally alter the nature of what it provides. And also a failure to take such steps as may be necessary to ensure that no individual with a disability is excluded on the basis of an absence of auxiliary aids and services, unless that entity can demonstrate that taking such steps would fundamentally alter the nature of the goods, services, and facilities, or would be an undue burden. So here we have in Section 3 the requirement to alter policies, practices, and procedures in order to accommodate the disabled. In Section 2, rather, policies, practices, and procedures. And in Section 3, we have providing auxiliary aids and services in order to include the disabled in what is being provided. And the only exception to actually doing this is in the case of policies, if changing the policy would fundamentally change what you're providing to other customers. And in the case of auxiliary aids, if it would be an undue burden or would fundamentally change or alter the services being provided. So it's a very high standard for showing that you don't have to change your policies or that you don't have to provide auxiliary aids, or that a business doesn't have to do those things. Let's look specifically now at what exactly some policy issues are, for example, and then we're going to look at auxiliary aids, and that's when we transition into the question of accessibility on websites, which of course is going to be of interest to many people interested in this topic. So areas of public accommodation, access to areas of public accommodation, individuals with disabilities shall be permitted to be accompanied by their service animal in all areas of public accommodation where members of the public, program participants, clients, customers, patrons, or invitees as relevant are allowed to go. Now, I just want to clarify something here that frankly I find a little bit confusing, and I want to make everyone aware of it. In the definitions to the regs, a service animal is defined as a dog. But there is this section here that discusses miniature horses and making reasonable modifications to allow an individual with a disability to use their miniature horse if it's been individually trained to do work or perform tasks. Frankly, I think that everyone should change their policies to be sure that somebody with a service dog is accommodated, and we're going to discuss that more in a minute. And it would seem to me from this section that would apply to miniature horses as well, even though it's not specifically included within the definition of service animals. Okay. So under the 2010 regulations, an emotional support animal is no longer considered a service animal under the ADA. The Fair Housing Act still has emotional support animals as a service animal, and this is just a notice that went out from the Fair Housing Act, from the the Department of Housing and Urban Development regarding the Fair Housing Act, which says this notice explains certain obligations of housing providers under the Fair Housing Act with respect to animals that individuals with disabilities may request as a reasonable accommodation. There are two types of assistance animals: service animals and other trained or untrained animals that do work, perform tasks, provide assistance, or provide therapeutic emotional support for individuals with disabilities. I've gotten the inquiry from condos about whether or not emotional support animals are still required to be accommodated, given that the ADA is no longer defining them as service animals. And just note that it's actually the Fair Housing Act that those types of businesses would have to concern themselves with. So, but under the ADA, certainly, we have a service animals defined now as specifically trained to undertake tasks. I'm paraphrasing the actual definition, which anybody can look up, but emotional support animals, untrained therapeutic animals, are no longer part of that definition. Checkout aisles, another policy issue. Okay, so accommodating service animals in a business is a policy issue. It's our policy that we accommodate service animals, and it's required under the ADA, unless the exception of fundamentally altering goods or services applies. But I can't imagine a situation where that would be the case. Checkout aisles. A store with checkout aisles shall ensure that an adequate number of accessible checkout aisles are kept open during store hours, or shall otherwise modify its policies and practices in order to ensure that an equivalent level of convenient service is provided to individuals with disabilities as is provided to others. If only one checkout aisle is available and it is generally used for express service, one way of providing equivalent service is to allow a person with mobility impairments to make all their purchases at that aisle. So again, we're talking here about, there has to be a certain number of accessible checkout aisles and which ones have to remain open and when, and this is a policy issue, and again, can be looked up very easily by anyone, any business who has this type of an issue. This is the next policy issue I want to address here. Hotel reservations is one that has been the subject of a lot of litigation since the passage of the 2010 amendments, or the 2010 regulations. Basically, under the 2010 regulations, a public accommodation has to modify its policies, practices, and procedures to ensure that individuals with disabilities can make reservations for accessible guest rooms during the same hours and in the same manner as individuals who do not need accessible rooms. Identifying and describing accessible features in the hotel and guest rooms offered through the reservation service in enough detail to reasonably permit individuals with disabilities to assess independently whether a given hotel or guest room meets his or her accessibility needs, ensure that the accessible guest rooms are held for use by individuals with disabilities, reserve upon request accessible guest rooms or specific type of guest room, and ensure that the guest rooms are blocked for disabled individual reservations, guarantee that the specific accessible guest room reserved through its reservation service is held for the reserving customer. The bottom line here is that hotels and motels, however they take reservations for guests, they also have to be taking reservations for accessible rooms in the same way, and they have to be setting forth what the accessible features are of those accessible rooms. And the regulations, I don't have it here, and the guidance go further in describing that they also need to explain the accessible and inaccessible features of the hotel itself. This is an area that is very important for hotels and motels, and any hotel or motel owner that isn't familiar needs to read this very carefully, because again, there's been a proliferation of litigation in this area. Okay, here I'm just pointing out here more policy areas of note. Ticketing. Any business that provides tickets for a show or for anything else needs to be aware that there are specific regulations regarding ticketing and regarding seating for the disabled. Those are policy issues. Gas stations. This is a notice that was issued in May of 1999 by the Department of Justice, which requires that individuals with disabilities be provided refueling assistance. And if you note, next time you're at a gas station, you'll probably see a symbol of accessibility on a sticker on the gas pump with some instructions for how to get assistance. Some of the pumps actually now have buttons built in to to ring for assistance. Again, this is something that gas stations risk lawsuits by not complying with. This is a policy issue. It's creating a policy to assist with refueling.